First of all, I would like to thank you all for the support you have extended to Kala and hope you will continue the same thing in the future. Without taking any more time, I would like to welcome you all for today's estate planning, today's program, estate planning and trust seminar. And I'm inviting today's moderator, Neil Wilson, to introduce our speaker, Greg McCloskey, who we are lucky to have to join us tonight. Thank you all. Neil, it's your time.
Thank you, Johnny Angle. First of all, good evening to all of you and welcome to this quick seminar that we put together. There has been a lot of interest in our community for estate planning or to understand how to go about the whole of this process. So Greg is not a stranger to our community. Greg has already worked with Uruma. He's worked with a lot of Malayali families in helping them set up their estates helping them set up a living trust. And Greg is based out of Orange County. He has I think he's worked in the financial services industry for the last 25 years. Therefore, I'd like to welcome Greg. Greg has kind of a whole presentation decked out and ready. Greg, welcome. I'm going to spotlight you and I'm going to hand over this session over to you. I have your presentation ready, so the moment you're ready, I'll basically jump to that.
That's great. Thank you so much. And thank you everybody for taking the time to join me. This is great. I love being able to talk to multiple people at once. Makes my job a lot easier, and we're all in the safety of our home, so this is great. And try to make this as informative as I can. I've got a great presentation for you. I think I can educate you, get you some good answers, and I've got a great offer if you want to get set up with a living trust. I'll make it pretty easy. And as Neil had mentioned, I've worked with Uruma for several years. I've got probably 30 or 40 Indian clients throughout Los Angeles and Orange counties, and I think they're all pretty happy. That's why they referred me to you. So I think I'll do a good job for whomever decides to try to set this up. It's very comprehensive, very complete, and powers of attorneys, trust, the whole 9 yards. It's more than just a trust. It's a portfolio, and it's a good service that I do. I can make it real convenient for you in your home. Come out, meet with you, and get everything set up, notarized, and it's pretty seamless. I've been doing this a long time, 850 clients in Southern California, going back 25 years. So with that, I'm happy to go through the presentation if you want to start that up, Neil, and we'll kind of start addressing some of the issues and questions that are good reasons to set up the trust. So this is let's see, you want to go to the next slide? Do I have to scroll down? Are you going to scroll through these, Neil?
Yep, I'll be scrolling through them.
Okay. So these are the basics with planning your estate. Yeah, whether you're young or old, you've got issues with making sure that you don't have any issues with minor children, or if you want to make sure you pass on your assets to your beneficiaries with the least amount of time and stress and cost possible. And so that's what a good estate plan does. It makes sure that everything's going to pass per your wishes, and with the least amount of cost. You try to avoid any court involvement, which is called probate. You want to make sure that if you've got minor children, you've got a vehicle to help care for them till they become adults. Also with our portfolio, we do the powers of attorneys in case you get in an accident and can't make decisions for yourself, your spouse or adult son or daughter or friend is there to help you. So we've got all of that included with the portfolio. Let's go to the next one. Okay, so this is me. As I said, I've been doing this a long time, about 850 clients. So I've got a lot of experience specifically with trust going back 25 years, 850 clients. These have been tried and true in the courts of law, never been overturned, never had a client's trust overturned, changed whatsoever without their wishes. So it's been very successful. It works. And I do it for a very reasonable cost. We can get into that later. I've also enjoyed working with the Indian families through Aruma. These are, a great community. I compliment your community. You're very educated and family-oriented people, and it's really a pleasure to work with all of you. You guys are good people to work with, good Americans, honestly. So, real pleasure to know all of you. Okay, so why would you want to get a living trust? Well, if you have assets, if you have real estate worth more than $20,000, there's an extra zero on there. That should say $20,000. Or if you own combined assets of $100,000, by law in California, your estate is subject to probate. And probate is the superior court where they validate your will, they litigate it, they file petitions, they file public notices, and then they have to get a court orders in order to follow the wishes of the will, assuming those are validated. And at some point in time, maybe anywhere from 6 months to a year down the road, maybe 2 years, those wishes could be followed after a lot of time and expense. Your beneficiaries would finally receive assets. If there's minor children involved, it gets even more sticky. So I can address that a little bit more. Let's see what else we got. Timely resolution. It's very quick. A trust is quick. Minor children I've already touched on. If you become incapacitated, we've included healthcare and financial power of attorneys so that you got somebody there to help make decisions for you in the event that you can't. You just don't want anything getting tied up in the court making decisions for you. So a good estate plan is going to include all of those elements. Let's go to the next slide. Okay, so a will. A lot of people aren't aware that if you have a will, that's an invitation to the probate court. And the reason why is because they have to validate the will. You have to file to validate it. You have to go through a petitioning process. You have to basically litigate the will in a court of law. It invites lawsuits. People can come out of the woodwork and lay claim to the estate. And it's a public process. And a lot of people don't like the publicity. They don't like the time and the expense that it takes. It's far easier to pass your estate without having a will and use a trust. That's why people do living trusts. Costs of wills are going through probate can be, 5, 10, as high as 20%. Let's see, I think the biggest issue though is the headache of just dealing with the court system in California. Things are very slow and it just takes a long time. It's the last thing somebody that's grieving wants to go through is dealing with attorneys and courts. So a trust is going to be private and it's going to avoid the probate system. That's why 99% of my clients do a trust. Let's look at the next slide, please. Okay. Also, you've got issues with minor children. The nice thing with a trust is you can name your guardians. You can make sure that the trust is a vehicle to hold those assets until those children are of legal age. It's going to, as I mentioned, avoid the court system and probate, so you won't have any of those issues. And then if you did have any estate tax issues, trusts can give you the maximum protection and taxes as provided by law. So it's going to give you wins all across the board. Let's go to the next slide, please. So again, I've touched on this. When you've got minor children, that's very important. Pick somebody that you trust. You can name a backup or two, somebody that's going to be able to hold those assets in trust for those minors. Usually I'll have those held in trust till they're 30 or 25, maybe 30. You want to be sure you give your guardian or your trustee the discretion to help pay for schooling if they want to go to college. Maybe they have health expenses. Maybe they might want to buy a home. There's a lot of different things that might happen, but you do want to give your guardian or your trustee over those assets the ability to help those kids for their health, education, maintenance, support until they become legally entitled to receive the principal from their inheritance. So that's what we typically will do if there's minor children involved. We can go to the next one, please. Probate, as I said, it's a common term for litigating a will through the court system. Again, in California, if you own real estate in California, $20,000 be multi-millionaire, high net worth people. But if you own a piece of real estate, you've got a few bank accounts, a few investments, you're going to be well served by having your estate set up through a trust so that it's not going to be subject to the fees and depletion that's going to happen in a court process. And that's what probate does. And so even so with smaller estates on a percentage basis, it's going to eat a larger portion of your estate before that ends up going to your beneficiaries on a percentage basis. These are kind of an example of what the fees might be. It can certainly run more than that. These are statutory fees. And the interesting thing is, let's say you had $1 million house that maybe you owed $500,000 on. The probate fee will be based on the full $1 million, not the amount of equity that you have in your home. So again, if you have probate, it's just a really really unfair system. I don't know how else to put it. This is a great slide because what this illustrates is the taxable consequence of putting somebody's name on your assets. So, you know, a lot of people, in order to avoid probate, may want to take a shortcut and put somebody's name on their house, an adult son or daughter, as an example. The problem is when you do that, what's going to happen is you're going to gift your tax basis for capital gains calculations. So that cost basis, if you've owned that house a long time and you've got a lot of deferred gain in that property and you gift it to an adult son or daughter, well, guess who's going to end up paying tax on that? They're going to end up, that'll be taxable to them someday when they sell the property. The nice thing is if they inherit the property through a will or a trust, obviously the trust is the preferred way to inherit, but if they do inherit, they're going to get a step up in that basis so that when they do turn around, if they have to sell the house, that cost basis is going to be the current fair market value. It's a gift from the government. They will basically erase all the deferred gains in that property that you may have. So that tax is going to, you know, if you figure a 30–40% tax on $500,000 in gains that you may have in your property, you're going to end up saving the family about $150,000, maybe $200,000 in taxes. So whatever you do, if you know anyone that's put their friend or daughter or son's name on their property using a joint tenancy, this is the tax trap that is set up. Tell them to reverse that. They can reverse it. Do it the right way. Use a living trust. Any questions on that? Okay, well, next slide, please. So again, this just illustrates the problem if you don't get that step up in basis. So again, I do think from a tax perspective, obviously a trust is going to give you the best disposition, not only with your federal estate taxes, your capital gains taxes, it gives the most control. It provides a vehicle to hold assets for beneficiaries, for children, if that's going to be deferred out. Across the board, it's a pretty savvy way to set up your estate. It's going to be the least expensive from a tax basis. Let's go ahead and go to the next slide. Okay, so these are just comparisons between the different estate plans. The first two, if you don't have a will, or if you have a will, then that ends up in court. So if you don't have a will, the court will decide who your beneficiaries are going to be. The only difference between the first column and the middle column is that with a will, now the court at least knows who you want to receive your assets. But again, after going through petitioning and going through the court system, 6 to 12 months, maybe 24 months later, after the court makes the final determination, then it would be released to the beneficiaries. With a living trust, you don't have any of those issues. There's no involvement with the court. You list your beneficiaries very simply in the trust. And it should be a pretty simple matter. It really does make it quick and easy. The bottom of that exhibit, when you look at the cost of a trust versus a will, certainly a will is going to be less expensive to set up. But again, once you involve the court in litigating and settling your estate and having to go through all those processes, it's going to end up being a lot more expensive, and it's going to be a lot more time consuming. Depending on where you go to set up your trust, I've seen them as low as $300. I've seen them as much as $5,000. This is actually a little low, on the low side. A lot of our attorneys that we work with on the more sophisticated plans may charge $3,000, $4,000, $5,000. We do a pretty simple trust. My fees for your group are going to be $625 for the next 60 to 90 days. My typical fees are $800 to $1,000, but I'm going to honor what I did for Aruma. These are pricing models that went back 2 years, 3 years. So I'll honor the 625, but do know that my fees are a little bit higher than that. It's generally under $1,000. That $1,000 includes all your notarizations. It includes all of the different documents in the portfolio. I'll do the deed preparation. It's the whole 9 yards, complete service. And the quality of the trust is excellent. It's extremely comprehensive. Any questions on that? Okay, so let's see here. So what is a trust? Basically, a trust is just a method to hold title to your property. It's kind of like owning, you can own property individually, joint tenant, tenant in common, through a corporation, through a trust. A trust is a simple pass-through entity. You maintain your assets through the trust. You have ownership and control of the trust. You can spend your money, sell your house. Nothing is going to change. You can also make changes to your trust. So these are revocable, amendable trusts. You always have control and can make changes. Pretty simple instrument, very common. Generally, if you're working with banks, real estate institutions, investment institutions, they're very familiar with living trusts. So you shouldn't have any issues on ease of management. It's not going to make your life any more difficult. Certainly won't make it easier, but it's not going to complicate matters. Let's go to the next one. Okay, so with our portfolio, we do a complete trust. It includes a certification of the trust. If there's any community property issues or separate property issues, we can incorporate that into the trust so that, excuse me, the character of your property going into the trust is going to be the same as character coming out. The pour-over will, which is essentially a last will and testament that just says, hey, I'm married, I've got kids, but everything is distributed through my trust. The will does not distribute anything. Also, you've got a financial and a healthcare power of attorney, which essentially appoints somebody to help you make decisions in the event you get in an accident or can't make decisions for yourself. Really important. I'll help make sure that you've got the proper quitclaim deeds on any real estate that need to be transferred into the trust. That's very important. If you neglect to put your real estate in the trust isn't going to protect you. So a very important part of my service is making sure that it's properly drafted, make sure it's properly recorded. So I help you do all of that. Assignment forms, transfer notification letters. So anything you need, any tool that you need to make sure that your assets are inside that trust, that's included in the portfolio. Now, I did actually print up a trust. I have a client. This is for another client that I'm working with. I'm going to just open this up so you can kind of get an idea. It comes in a binder. And this binder, let me see here. So this binder.
Greg, 1 second. Let me just.
Is that not working?
1 second. Let me just stop the screen share and just share your make you a spotlight. Give me 1 second.
Okay. What if I just put it like this? Oh, yeah, I see you want to put me on the front and center, right?
Yeah. That's what I'm trying to do.
You want me to do this after we do the presentation? I can go through it at the last
Yeah.
part?
Yes, please.
Let's do that. So we can come back to this. I'll come back.
Got it.
Okay, so, but the bottom line is with this portfolio, it's very, very comprehensive. I've thrown everything in there that you could possibly need. It's even got a settlement instruction section so that whoever is going to be the successors on this thing knows how to settle it. If they have questions or issues, they can call me. I plan on being around for a while. I'm only 53 years old. I know I've got a lot of gray hair, but I plan on being around for a while. And so, yeah, it's very comprehensive. And if people have questions going out in the future, they can always give me a call if they acquire new assets, not sure how to put that into the trust. I keep files on everybody. All 850 clients I've got, I can pull up their documents. I know what everybody has. I can always help them make amendments or deal with issues that might come up with them or their beneficiaries, or help them make amendments if that's what they want to do. Okay, so I provide a pretty good service. Let's go to the next, let's go to the, oh, wait, I didn't cover all that. If we go back, I'm sorry. We'll go back. Okay, so trust, let's just make sure I've got all these covered. To prevent probate, cost effective, retain control, protect during disability, flexibility, privacy. I pretty much covered all of those. Does anybody have any questions on this at this point? Okay.
So if any of you have questions, I'm sure a few of you have questions. What I'll do is just raise your hand. That's an option, and I will unmute you. I've basically muted everybody. So just raise your hand, and I will just unmute you, and you can ask your question.
Okay. All right.
I think
So,
Tommy Chera, you had a question, right?
Can you hear me?
Yep.
yes.
Yeah, there are some questions, shall we wait at the end of the presentation or in between?
Well, let's see. Do we have, how many more slides do we have, Neil?
I think we have 2 more.
Let's finish the slides and then we can do some questions.
Okay, one is this, it says avoid multi-state problems. What is that?
So if you have property here in California, let's say you own a home in Nevada, in Las Vegas, as an example, your property would be subject to probate in each and every state, in each county where you own property. So you could effectively have 2 probates. You could have one in California and you'd have to get one in Nevada. So every state where you own real estate is going to open up a whole new probate. There's not just one probate, it's state specific.
So if you have a revocable living trust, does that supersede that? So a revocable living trust prevents probate in 2 separate states.
Correct.
Is that right?
Correct. As long as your assets are in the trust, and I've got clients up in Washington, back east, Florida, New York, all over the country. They've got properties everywhere. As long as they're in your living trust, this trust works in all 50 states. It'll avoid probate in anywhere, any county that you have property, in any state.
Great. So I think the cost, you had already mentioned the cost, it's $625, right?
Correct. So the reason why I'm doing that is that was a price that I set with Aruma back in, gosh, it's probably been at least 2, maybe 3 years. That pricing I, gave them, and I'm willing to give that to you. Maybe you've already heard that cost. And if you know anybody in the Aruma group, I've probably got 30, maybe 40 clients out of that group. I've got quite a few. And I normally would charge maybe $800, $900, maybe $1,000, depending on how complex the estate is, if there's a lot of property. But generally it's about $800, $900 for a trust. I'll honor the $625. If anybody wants to do this in the next 60 days, I'll honor that price. It's a limited time. And next year, if somebody calls me up, I don't know that I can honor it, but I mean, I'm happy to still do the same trust. It's typically about like I said, $800, $900 for the trust.
So that fee is for one person or for husband and wife?
It's going to be 1 or 2. So whether you're married or single, it's $625.
Got it. Cool. I think we've come to the end of the deck itself. All we have are questions. So the ones that have questions, either raise your hand, or I can. There's an option to the right of your screen, to the bottom of your screen. It should be to raise hand, and I'll unmute you. Yeah. Or if you're on video, you can just wave at me as well.
I must have done a great job. No questions?
Yeah, let me ask you, can we have both a will and a living trust, or either one, or how that works?
Okay, so part of our trust portfolio is what's called a pour over will. It's a last will and testament. It has a pour over provision that pours your personal articles into your trust. It's an ancillary document. It's almost moot because it doesn't distribute anything. What it does say is that, you know, it'll have declarations such as you're married, you live in a certain county, you have kids. It defers all of your property to your trust, and the trust is the instrument that distributes assets to your beneficiaries. So yes, a will is part of the trust, but it's not a distributing instrument.
So you said that, you know, it's a revocable trust, and if you want make amendments, so how much you charge for that one, you know?
So that depends. So typically, people don't make amendments very often, and if it was something really simple, I might charge you for my time, maybe $50 or $100. If it's an update, let's say I meet you 10 years out. I do a lot of updates for clients. A lot of things change. Maybe they've got a number of amendments. Maybe they need to update their powers of attorneys. Generally, you don't want your powers of attorneys going older than 5 years. They've also changed the forms. So typically I'll do a portfolio update. Usually that's $200-300. That might happen once every 5 years. It just depends. Some people don't do that, and they just let it go longer. I mean, it's really up to you. I'm happy to offer updates. They're pretty inexpensive, pretty reasonable, but I do charge a little bit for my time. I can't, you know, work into perpetuity for free, unfortunately, but you know, I don't see people disinheriting kids too often. Changes might usually be a change of trustee. And again, probably the more prevalent one is where I see people just updating their powers of attorneys, or maybe they had minor children who are now 18 or 21 and they want to appoint their kids as trustees or have their kids as their power of attorney. That happens actually a lot. I've been doing this enough time so that, you know, a lot of these youngsters that were young when I set up these trusts are now adults. So, but that's available if you want it, and you can work through me or you can find somebody else. I don't think you'd find somebody that could do it as efficiently and cost effective as me, but you're certainly welcome to try.
Awesome. We have a couple more questions. Let me go to Manish next. After that, I'll go to Mr. Menon, and then I'll come back to Tommy Chetton. Thank you, Tommy Chetton, for your question. Manish, can you hear me, Manish?
Yeah, thank you, Neil. And thanks, Greg, for your presentation. My question was similar to the question somebody asked earlier. How difficult is to change an irrevocable trust that has been already created? Say if you want to add a new house or a house is sold, what is the process? Is it a difficult process, a lengthy process? How much time it takes? It's similar to that line only.
Okay. So let's look at what would happen if, for example, if you bought a house. So if you, let's say that you have a house now and, you know, you sell your house and you could take that equity and you roll it, you buy a new house and you want to make sure that you put that property into the name of your trust. Well, one of the things that the escrow agent will ask you is how to title that property. And you have a couple of choices. You could entitle it to yourselves individually as joint tenants, tenant in common, community property. Let's see, you could do it in a trust, you could do it in a corporation. You have a whole bunch of choices. So with the trust portfolio, you'll actually have the documentation that you could provide that shows you have a living trust, you have a vehicle, and you can just instruct them to put it right into the trust. Now, let's say that you do some financing and the finance company doesn't want to deal with a trust. They'd rather deal with you as an individual. So you set it up and you buy the property. You've got a mortgage on it. It's in you and your wife's name as joint tenants or as a single person. At that point, once you've complete the purchase of the property, you'd want to do a quitclaim deed to put it into your trust. That's very important. And you could call me to do it. Usually I'll charge you anywhere from $50 to $100 to do that. It's not an exorbitant expense, but it does need to get done.
Sure. Thanks, Greg.
Yeah,
Awesome.
It's pretty simple, honestly. It's not real complicated.
Awesome. I'm going to go over to Mr. Menon next, who had another question.
Hi, Greg. It was
Hello.
it was a very clear and succinct presentation. Thank you so much. I have a
You're
question.
welcome.
We have 2 kids, and I want to know whether they are outside in another state. Do you do trust planning and everything else for the kids also from outside the state? Outside state.
Kids in.
They're not kids. They were kids when we had the trust, but they're adults now. So we want to change them to different.
Yeah.
trust.
So are you saying they're adults now?
Yes.
Okay. So if you have a trust, perfect, goes right back to my example where they're now of age and you want to amend your portfolio to reflect them as your alternate trustees, that's, you know, that's probably the best way to go. I mean, keep it in the family, keep it simple. But yeah, you'd want to update your portfolio that you currently have. Now, a lot of portfolios, if I go out and I see a trust that's 10, 15, 20 years old, depending on, you know, how the trust looks, if it's statutorily outdated, they don't have updated powers of attorneys, they don't have health care, a lot of the things are missing. A lot of times it's easy for me just to create a new document and put it as an amendment and restatement on the old trust and just use the new document as a functioning document. And that's basically an amendment and restatement. So I do, you know, I do those on older documents if there's just so many little things that need to be fixed. It's oftentimes cheaper and cleaner just to do a new trust at 625 or 800 or whatever the number is, as opposed to going in and doing 10, 15 amendments on that old document that may be really outdated. So that's a pretty simple thing to do. It's really not complicated. It's very clean. You essentially have a new estate plan that's up to code and, you know, has all of your current wishes the way you want them. And it's, you know, again, pretty cost effective.
May I ask you one more question? Do you
Yes.
do trust for people from other states? From
I
Illinois?
have. I just did one for somebody in Florida and I did one for somebody in Washington. Last year, I probably did 3 or 4 out of state. I don't do a lot, but I do get requests for that.
Thank you.
Thank you.
Awesome. Thank you so much, Mr. Menon. Up next, I have Ramesh, who has a question. I've unmuted you. Go for it.
Hey, Greg, thank you so much for doing this. It's very helpful, useful information. So the question I had was more on properties out of state. So what is the extra work that needs to be done, or do we need to do something in the other state as well, or everything is taken care of here in the documentation that you do? So what is extra needed there?
So thank you for asking that, because I do charge a little bit extra when I'm doing an out-of-state deed. So what'll typically be included in my portfolio would be two California deeds, okay? And then if you've got properties out of state, I may charge you, you know, $75, maybe $100 to put that in. And the reason why is because I have found that when you call across the country, every county has different requirements. They usually have their individual form. For example, in Washington, I have to deal with sending the deed to the treasurer first to get the excise tax stamp on that document before it's a recordable instrument. And they have a special form that's a legal size form in triplicate that needs to be produced. And there's just a lot of little intricacies when you're dealing with out-of-state counties. I've got the LA and Orange and San Bernardino, San Diego. I've got a lot of the California counties down pretty well. But again, when I'm dealing with out-of-state, I got to make phone calls and put some time and get it done. And I don't have a problem getting it done. It's just a little bit more work, and it's going to cost a little extra money, but it's basically just to cover my time and dealing with the harder work. That's where the work is when you put these things together.
Okay, thank you.
Yeah, you're
Awesome.
welcome.
I think we're gonna go back. We have another question from Tommy. I'm gonna go to Tommy Chen. Tommy.
My friends sent to me, you know, one is this, like if after a country, properties like in India, you know, can we include that on the trust, or
Okay,
instead
good
when it's
question.
out of state?
Good question. So with the trust is valid in the United States. And I can put everything on paper here, how you want your assets distributed. Now, what I've done with a lot of my Aruma clients, they've had houses and property back in India. What we typically will do is I'll go ahead and I'll list that where we list beneficiaries, and I'll make specific reference to those properties. They'll email me the addresses, and I'll fit that in, and I'll make I'll make a provision that it, you know, basically parallels the way that they want, you know, however they want that property distributed, so that at least you've got it on paper here in the United States. Now, in India, I understand that their inheritances go through the banks over there. So as much as I can do here to, you know, put your wishes on paper, and I don't know that it's enforceable by law in India, but at least you've got a roadmap on how you want assets distributed. And it would be incumbent on you next time you travel home to go work with the local bank and make sure that, you know, your legal paperwork in India is going to match and satisfy what you've wished for and penned on paper here in the United States. But I do put whatever you want, whatever assets you want listed in your trust. I'm happy to put them on the schedule of assets, including overseas property. And we can make note exactly how you want that property distributed, and that's fine. But again, when it comes down to legal enforcement, I think in India, you're going to have to make sure that you work with somebody back home that can put whatever type of legal paperwork together that you need back in India.
Okay, another question, you know, in order to execute a living trust, that to be a US citizen or can be green card holder?
You don't need to be a US citizen, and, you know, green card holder, that's fine. But no, to execute, all I have to do is notarize your signature. If you own the assets, you've got a legal entity. A trust is a legal entity, and you can basically manage that and own it and hold property in there. And yeah, it shouldn't affect it either way.
So what happens, you know, if we live in California and later we retire and move out of state? So what happens to the living trust?
So the trust is going to be valid in all 50 states. So if you do move, let's say you sell your property here in California and you retire to Arizona. I've had a lot of clients do that. So when you buy that property in Arizona, again, it comes down to notifying your escrow agent how you want that property held. And if you're going to have financing on it and you've got to put that off, that's fine. At least you take title to it. And once it's in your names as joint tenants or, you know, as a single person, however you've got title at that time, then at that point you make sure you do the transfer via a quitclaim deed. So it's just same process.
Okay, good. Another question. What happens, you know, this is a revocable living trust, but husband want to revoke it, but wife said no, then what happens?
Then you got a problem. So it's a joint agreement. Technically, each of you have half the assets in the trust, technically. If one of you wanted to revoke it and change it and the other didn't, I suppose one of you'd have to sue the other. You'd have to start a court action against the other. I've never seen that, honestly. I've been doing this a long time, 850 clients. I've never seen a situation where there was a substantive disagreement to where they couldn't make the trust operable. Now, if there was a separate property issue, there is a separate property agreement, which basically states that the character of property going in will be the same as the character of property coming out. So if a husband had a house or the wife had a house and they put it in the trust and they want to remove it, they have the authority to do that. So there are protections with separate property, but with community property, if there's disagreement on it, you know, I live at home with my wife. We jointly own a home. I guess if she wanted to sell the property, but I didn't want to sell the property, I guess she could sue me. Or I would sue her. I've never seen it though. I've been doing this a long time, and I've reviewed twice as many trusts as I've ever created. I've probably reviewed 2,000 or 3,000 trusts. I've never seen that. So that's a very interesting question. Now you've piqued my curiosity on that.
So what happens, you know, when the husband and wife, you know, they divorce? So still this is valid or become invalid?
So if you divorce, the trust is going to be split. So whatever assets are in there, they're jointly held assets. It really doesn't change how a divorce would split assets. I mean, it's going to be the same whether it's held in a trust or say joint tenancy. It's going to be equally split.
Awesome. Awesome. I think we have one more question. Ramesh bhai, go for it.
No, I actually wanted to ask about the divorce, but Tommy had that follow-up.
Wow, a lot of divorce questions.
That's a great question. Or what if they move overseas back to India and they want to take all the assets back there, right? Let me do this. Would you like me to kind of show you what this portfolio looks like? You want me to do that real fast?
Yes, absolutely.
Yes,
Go
please.
for it.
Okay. Let me see if this is going to work. So I'm just going to, this is prepared. This is what it looks like.
You may have to remove the virtual background because I think all the paper gets removed.
Okay, let me do that real fast. I would like to just show you what this thing looks like because it's in a binder. It's pretty well organized, and just kind of so you see. So okay, so let me go to none here. Okay,
Yep.
so, all right,
All set.
all right. So this is a client portfolio. I'm going to back up a little bit. Okay, so you see all the sections here. We got an overview of the trust document here. This is about a 20-page document. Your Schedule A of assets, your transfer documents, comprehensive transfer document, assignment of personal effects, furniture, furnishings. That's in here. Also, any notification directives. I've even got a virtual or digital property assignment in here. That's new and updated. Here you got a gifting section where you've got, I'll put that up closer so you can see directives where you say, I want to give my jewelry to somebody, or I want to donate $10,000 to the church, any specific gift. So beyond an equal split between kids, you may want something of sentimental value, a coin collection or a watch. It could be anything. You can come right in here. That way we don't have to do an amendment or do major surgery on the trust here itself. Then you got that pour over will, which is right here. Just again, doesn't distribute assets. It just says everything is going to be distributed through the trust. Financial power of attorney here. The healthcare powers of attorney are real nice because it's got not only the advanced healthcare directive, but it's got a HIPAA declaration, which is basically a definition for incapacity that's well defined. Also an authorization to release medical records in California, which is important. There's a lot of privacy laws. Certificate of trust, shortened version of the original, only a 2-page certification, no beneficiary information. Settlement instructions here so that your beneficiaries, this is just more organizational so that they know, what they need to do in order to settle the trust. It's usually a very simple matter. And then miscellaneous forms down here, quick amendments, those kind of things. But if you do want to make an amendment, I would call me before you do anything by yourself. And it's probably a good idea to make sure you know what you're doing first. Okay, so this is, I've got my card in here. If anybody ever wants to refer me, there's going to be a postcard. This right here, this is an amendment. This goes to the county. This is the deed the deed that I prepared. This right here is what's going to be recorded. This original paper with the wet signature notarized will be stamped up here. This comes back to you. Also in this deed, there's a form that goes to the county. This form is really important because this form tells the county that you're not selling the property, so it's not going to be reassessed for Proposition 13. You maintain your low taxes. So all of these forms, everything is prepared. The only thing you got to do is just sign this thing and then mail it to the county. And here it is. It's already addressed. You put your stamp on here. The fee is $27. I'm going to let you pay that. If it's a rental property, there's an addition, basically a similar fee with an additional $75 tax that's exempt on your home. So if you have more than one property, recording fees are probably going to be several $100s. But basically, this is all prepared. This is all turnkey. This is ready to go. once I visit and we execute all of these documents here, we execute this deed, this goes off to the county to be recorded. This is pretty much done. There's not much left to do. And that's what you pay me the $625 for. I do all the notarizations, make sure it's properly executed. And I can pretty much do this blindfolded. I've been doing this long enough. But it's a nice portfolio. This is very, very complete. And when you come in here, you know, you've got your trust document. You've got your schedule of assets in here. I don't know how clear you can see this. All these documents. So it's all in here. There's going to be about 20 notarizations by the time we go through and do these different funding documents, the powers of attorneys, all these. With a couple, typically you got about 20 notarizations. That's all included in the fee. Takes about an hour to do this, to notarize everything. Now, if you guys do decide that you want to work with me, and with this COVID thing, I've been doing a lot of emails. This is actually an email template that I've sent out. And basically what this is just an email that I can send out. And if you decide to, you know, fill this out and put in names of beneficiaries, who you might want as your successor trustees or alternate powers of attorneys, if you get me this, not only will I make sure the spellings are all correct, because I've got some pretty tricky spellings with the Roomba clients, but I'll have basically everything I need here. And if I'm missing something or you have questions, we can certainly talk on the phone. But this makes it very easy for me to construct this, so we don't even need to do it an initial meeting if it's not necessary. So, you know, I've been doing this a lot lately since everybody's been holed up and trying to avoid contact with people. But I've been doing a few trusts, just doing the emails, and I can make it pretty darn simple, at least give you an idea of what information I need. And once I get this, I can go through it, make sure, you know, typically it's going to be adult sons and daughters on here. Give me your address of your home. If you've got a deed, that's good. Otherwise, I can run a county profile, get all the legal information I need. But typically, it's pretty easy. And but I can work with emails. You give me a call, and happy to send you the template. We can work it that way. Whatever makes sense for you is going to save you some time, make it easy for me, prevent us from having to meet too many times. If you're wary of, you know, the pandemic and all that, it makes it a lot simpler. So I'm trying to make it as easy for you as I can.
Awesome. I think we have one more question. Sorry, Greg, you were speaking.
Yeah. I was just going to say, any other questions? So let's have it.
Yeah. Ramesh?
Yeah, so we execute this will. I have a executor who would kind of act on it if something happens. So how does the person access this, or do I need to give a copy of my trust to him, or what happens in the event of something bad happening?
Great question. So what I'll typically do is when we'll have this trust, we'll execute this trust. And what I would do is I'd go right in here to section 2. This document, right? Where's that trust? Where did I put that thing? Here it is. In the wrong section. Okay. So what I would typically do is I'd pull this document out, and the powers of attorney, whatever documents you have, I would just pull this out. I would make a copy of this document. I would put the copy in here. I would take this original and send maybe a copy to your friend. Take this original. You can fold this up, put this somewhere safe. You want to make sure you keep your originals. You don't want to lose them. But your trust, if you have a copy, it's a working copy. Same thing with your financial power of attorney, your healthcare power of attorney. These are documents that you do want to get in the hands of whomever you've appointed. So make sure you make a copy here. It's a working copy. And if you want to scan it and email it to them, that's fine. But absolutely, you got to make sure they know how to get their hands on it. Also, I'm usually pretty good about when I write in trustee information, I'll put any contact information, including phone numbers. So whomever you list as your primary power of attorney or executors, all that stuff, I'll go ahead and I'll put all that contact information right into their trust there, so they can see it and we can find them. I don't know if you can see that, how clear that is, but you know, I'm pretty careful about making sure that these people know how to get their hands on the document, know where to find them. You know, that's very important. And then if they have any questions or they need help, you know, they can just call me. So I help people do settlement issues or do affidavits when somebody's gone if kids have questions. I've been doing this a long time. So
Awesome.
Okay.
Awesome.
Thanks.
Any other questions? Please raise your hand because we have like a lot of people. So
how many people do we have now, out of curiosity? Do we?
I think we have about 30 people, and at one point I know it was like close to 35.
Very nice.
Yeah, we're also
Very
recording
nice.
this session, so at the end of it, it'll be up on our social media. Okay, I think if we have no more questions, I'd like to hand it over to Ramesh, who's the Secretary of Color. Ramesh, all yours.
Yeah, I'd like to
One
thank
second, I'm sorry.
Greg.
1 second, let me just spotlight you.
There he is. Hello.
Thanks.
Hello.
Hey, Greg. Thanks for answering all those questions. And thank you so much for doing this for us. This is very helpful. A lot of us have been having questions about this, but this is something which we haven't got to yet. And with this pandemic going on, I think this is a great time to kind of get us all together and have all these questions answered and look into actually doing this estate planning. So thank you so much for educating us. I'm sure a lot of us would be reaching out to you. And I'd also like to thank everyone who logged in today. Thank you so much. It's a Friday evening. You could have done something else, but we do appreciate you taking your time and coming over, listening to this. And we do appreciate all the support that you give to Kala. Thank you so much. Stay safe, everyone. Thank you so much. One last thing, as Neil said, this would go on our Kala Facebook page. So the recording would be available maybe tomorrow or so. So for those that couldn't attend, please share it with them so they could also look into this. Thanks, everyone. Have a good weekend. Bye.
Thank you, everybody. Good night.
Thank you, everyone. Have a great night, great weekend. Thanks again, Greg. Really appreciate
My
it.
pleasure.
Once the video is up, once it's ready, hopefully it'll be sometime Sunday, I'll make sure I link it to all of you that have participated. Thank you once again. Have a great night. Bye.
Awesome. Thank you,
Oh,
everybody. Good night.
thanks, Neil. I forgot to mention that.
That's okay.
Thanks for coordinating. This was awesome. Thanks, Neil.
Yeah, he did a great job. Thank you, Neil, again.
Thank you, everybody.
All right. Good night,
Thanks, guys.
everybody.
Bye.
All right.
Bye.
Bye-bye.